What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And this one's a big one. The Ninth Circuit Court of Appeals has denied Zuffa's request for permission to appeal Judge Richard Boulware's class certification order allowing the Kung Lee plaintiffs to proceed as a class for the bout people within the bout class. Big news because now, assuming that everything goes according to the plan, which it usually doesn't, the trial date for the UFC antitrust lawsuit will be April 8th, 2024. Now, obviously things can change. There could be motions to extend the trial date or to continue the trial date. There's a motion for summary judgment that we'll talk about in a later legal submission that could actually dismiss the lawsuit. But the big thing here is that the Ninth Circuit denied permission for Zuffa to bring this appeal. Now, it's not a substantive issue, it's actually a procedural issue. And that is based upon the Ninth Circuit's hesitancy to utilize appellate resources for interlocutory appeals. Interlocutory appeals are appeals that occur prior to a final judgment being rendered. That's basically my definition right off the cuff. But basically, if there is not a final judgment and a party appeals, like here with Zuffa, that they call that an interlocutory appeal. Ninth Circuit, notably in an order allowing the U.S. Chamber of Commerce to file an amicus brief on behalf of Zuffa, in the second paragraph, they actually just deny it outright. And they cite a case, and the case describes Rule 23F regarding the class certification and the methodology as why the Court of Appeals decided not to take this case. It's rare. Obviously, Zuffa probably knew that, but believed that there were circumstances that were necessitated to bring the appeal. Obviously didn't work. The Ninth Circuit still stayed on its policy that it would not review interlocutory appeals, and therefore the trial date is going forward. Now, the UFC has, Zuffa and the UFC have filed a motion to reopen discovery, probably not going to win on those merits. The Johnson case, Cajun Johnson and C.B. Dalloway, also are trailing this particular one. So that probably will pick up as well as this case continues toward its final destination, maybe, which is a trial date. Now, with all that being said, what is to become of Zuffa with its appeal? Since it was a procedural error, it's not a procedural error, since it was a procedural denial, the UFC can still come back and challenge the certification by Judge Boulware once a judgment is rendered by the trial court. But that, of course, means time, expense, and costs on the part of all the parties. And we won't know what will happen at trial, whether there are other options for Zuffa or not. Good news for the plaintiffs is that they overcame a major hurdle here. I believe that this was going to be appealed before going to trial, and it's not. This puts them in a good position, notwithstanding the motion for summary judgment. That's still a big one to overcome, which we'll talk about. But if they are able to get past that hurdle, there is a greater potential for this case to be settled or go to trial. We'll keep up with this as more things come up. It's Jason Cruz with The Legal Submission. Have a good day.